Good afternoon, everyone. The next item of business is statement by John Swinney on the United Nations Convention on the Rights of the Child, Incorporation Scotland Bill, a revolution in children's rights. The Cabinet Secretary will take questions at the end of his statement, and so there should be no interventions or interruptions. And I call John Swinney. 10 minutes, please, Cabinet Secretary.
Presiding Officer, I am delighted to confirm that the United Nations Convention on the Rights of the Child Incorporation Scotland Bill, which was introduced to Parliament yesterday, has today been published and will begin its parliamentary passage. This is one of the most significant pieces of legislation to be considered by Parliament in the 20 years since devolution. It is a bill of the highest constitutional and legal significance, but one which must also transform the lives of our children. If approved by Parliament, this bill will mean that Scotland is the first country in the United Kingdom to directly incorporate children's rights into domestic law. I want to thank the children and young people and children's rights defenders who have campaigned for this bill and made it possible. The Scottish Government is committed to fully realising the human rights of all people in Scotland. We are committed to building a Scotland where respect for human rights anchors our society and the institutions which govern and deliver public services for the people of Scotland. The bill represents a significant step on the road to fully realising that future for Scotland, a future based on tolerance, equality, shared values and respect for the worth and human dignity of all of our people. The dual impacts of the COVID-19 pandemic and the United Kingdom's withdrawal from the European Union underline the importance of human rights being built into the fabric of society. Nowhere is this more important than in relation to children and young people whose futures depend on the action taken by all public authorities to implement their rights in practice. Children's rights matter now more than ever. The United Nations Convention on the Rights of the Child is the global gold standard for children's rights. By incorporating these rights directly into the law in Scotland, the bill will revolutionise how we protect, respect and fulfil children's rights. It will ensure that children and young people are involved in the decisions that affect their lives and communities. Where breaches of children's rights occur, the bill will mean for the first time that children and young people can use the courts to enforce those rights. The bill takes a maximalist approach and will deliver the highest protection for children's rights possible within the boundaries set by the Scotland Act. The rights and obligations in the UNCRC and the first and second optional protocols are incorporated fully and directly using the language of the Convention itself to the maximum extent of the Scottish Parliament's powers. It is of fundamental importance that all children and young people can access and enforce their rights. I can confirm that the bill will therefore apply to all children and young people under the age of 18, in line with the recommendations of the Committee on the Rights of the Child. The definition of public authority in the bill has been drawn intentionally wide. The duty in the bill will apply to public authorities to the fullest extent possible within the powers of the Parliament. This includes the devolved functions of core public bodies like local authorities, health boards and the police, and the devolved functions of public bodies with mixed devolved and reserved functions. The bill makes it clear that the duty applies to the Scottish ministers and the courts. The duty in the bill also applies to private bodies when exercising functions of a public nature. Whilst the duty cannot apply so as to modify the law on reserved matters, it may apply in some circumstances to reserved functions where this could not modify the law on reserved matters. This will require that careful consideration must be given to the circumstances of children and young people in practice. Human rights can only be fully realised in Scotland if all the institutions of the state take action to respect, protect and fulfil the rights that belong to every member of Scottish society. That would include this Parliament. The Scottish Government recognises that further consideration requires to be given by Parliament itself to how the requirements of the bill should be applied to its functions, and looks forward to working with members of Parliament on this question during the passage of the bill. The duty on public authorities in the bill follows the model of the Human Rights Act, requiring that public authorities must not act incompatibly with the rights and obligations incorporated by the bill. The duty in the Human Rights Act is well understood, and the approach will provide as stable a framework as possible. Children have their human rights, as set out in the European Convention on Human Rights, protected by the Human Rights Act. This bill ensures that children and young people have legal protection for their children's rights also. My ambition has been to ensure that the bill puts in place the highest level of protection for children's rights as possible. My preferred approach would be to require all legislation, past and future, to be compatible with children's rights, with the courts having the power to strike down incompatible legislation. That reflects a founding principle of this Parliament, that this institution exists to serve every member of Scottish society. The power to pass legislation that breaches human rights is not one which this Parliament should have, and nor do I think it is a power which members wish to have. However, provision requiring future legislation to be compatible with the UNCRC would alter the competence of the Parliament and is not therefore something that can currently be delivered by an Act of this Parliament. In line with the maximalist approach, it is my intention that a court should be able to strike down legislation where this is possible. The bill therefore provides for different remedies in relation to legislation that predates and postdates commencement of the bill. The bill will enable the courts to strike down incompatible legislation which predates commencement of the bill. For legislation that postdates commencement of the bill, the courts will be able to declare that legislation incompatible. The bill also ensures that damages can be awarded by the courts by way of just satisfaction. The benefits of this approach will be that as far as is possible within the powers of this Parliament, breaches of children's rights in historic legislation cannot endure. In relation to future legislation, a finding by the courts that legislation is incompatible will bring transparency to breaches of children's rights. Other measures in the bill put in place a very strong framework to ensure compatibility of legislation with children's rights in practice. The bill requires Scottish ministers to publish child rights and wellbeing impact assessments and to make statements of compatibility for government primary and secondary legislation. This will bring greater transparency and accountability for children's rights into the legislative process. Ministers will also be required to undertake child rights and wellbeing impact assessments in relation to strategic decision-making. The bill requires ministers to publish a children's rights scheme on an annual basis, setting out what arrangements they have made or propose to fulfil the UNCRC compatibility duty. Ministers will also be required to report on the progress made and plans ahead for children's rights. The children's rights scheme and reporting requirements will aid transparency and scrutiny of how the Scottish ministers fulfil their obligations under the bill to ensure that children's rights are considered proactively and fully implemented in practice. Building on the progress made under the Children and Young People Scotland Act 2014, public authorities which are listed in the bill will continue to be required to report every 3 years. Children and young people face additional barriers to realising their rights and accessing justice. The bill introduces specific measures in recognition of this fact. These include ensuring that claims are not time-barred during childhood and giving the Children and Young People's Commission in Scotland the power to raise claims in the public interest. In order to bring further transparency and accountability for breaches of children's rights, the bill will require Scottish ministers to report to the Scottish Parliament within 6 months following a court's decision to strike down or declare legislation incompatible. The bill will also include remedial powers similar to those that exist in relation to the European Convention on Human Rights, to enable ministers to take steps quickly to amend legislation which is found to be incompatible or which is potentially incompatible. The bill builds upon a strong track record across public authorities of implementing children's rights in Scotland. The Scottish Government is committed to ensuring public bodies are supported to fully implement the bill and will work in partnership with them on a £2 million implementation programme over 3 years. The bill will mean that children, young people and their families will experience public authorities consistently acting to uphold the rights of all children in Scotland. It will ensure that there is a proactive culture of everyday accountability for children's rights across public services in Scotland. The Scottish Government wants a Scotland where policy, law and decision-making take account of children's rights. We want a Scotland where all children have a voice and are empowered not just to know and understand their rights, but also to assert and defend those rights and the rights of others. Fully realising the fundamental human rights of children and young people is essential to building the more prosperous, equal future which the Scottish Government wants for everyone in Scotland, especially for our children. Today, we embark on a parliamentary journey to fully realise the rights of all children and young people in Scotland. This is a landmark day to secure the rights and the future of Scotland's children.
The Cabinet Secretary will now take questions on the issues raised in his statement, and I'll allow around 20 minutes for that. After that, we'll move on to the next item of business. Would those members who wish to ask a question press the request to speak buttons now? And I call on Jamie Green.
Thank you, Presiding Officer. Can I thank the Cabinet Secretary for advance sight of the statement? These benches will fully support measures which protect and enhance the rights of children and young people in domestic legislation and those of international conventions. And I do commend the efforts of those in this chamber and out with who have been faithful to their promises on bringing this to this Parliament. We will work with the Scottish Government on this bill, scrutinise and improve it where we can, and make sure that the consultation is wide and respectful. But there is no doubt a myriad of very technical and legal questions which might arise from this bill, no least how this piece of law will work alongside the UK Human Rights Act, which itself transposes the European Convention of Human Rights into UK law. So can I ask, and this is largely a technical question to the Cabinet Secretary, what assessment has he or his government undertaking in advance of the publication of this bill between any interactions, interplays or potential conflicts between the rights as set out in this law, any other UK relevant legislation, laws of the European and UN respective conventions, and any areas where there are clearly divisions between what is devolved or reserved matters, any potential conflict between the above and the complex hierarchy and interaction between multiple conventions and pieces of law. And can I ask what firm mechanisms will be in place to ensure that any conflicts which do arise will be dealt with fairly, so that future bills passed by this Parliament do not spend needless or endless months in the courts, something which I think will serve no one any good.
John Swinney.
President Officer, I wholeheartedly agree with Jamie Green that there will be a myriad of technical questions here, and many of these questions are issues with which I have wrestled significantly in the course of the last couple of years as we have prepared this bill. The bill has been designed to try to avoid all of the challenges that Mr Green has set out. And I stress the word designed. Parliament will have to scrutinise that to satisfy itself that we have got the design architecture correct in the bill. Mr Green will know that this Parliament is required by virtue of the Scotland Act to act in a fashion that is compatible with the, our legislation must be compatible with the terms of the Human Rights Act and the European Convention on Human Rights. So and that is a requirement of the Scotland Act which we cannot breach, so that requires us to act in a particular way, and the bill is designed to be compatible with that requirement. There will, of course, be a range of questions where we cannot fully incorporate the provisions of the UNCRC because of reserved questions. And there are a number of technical examples of that, which, of course, we will happily explore with Parliament as we proceed through the scrutiny of the legislation. But we have designed a bill which has as its intent the enhancement of the rights and the protection of the rights of children and young people in our society, but in a fashion that is compatible with the existing legal framework within which we have to operate. Final point I would say is that Mr Green talked about the role of the courts And I suspect this will be an issue of some controversy. And I know that members will be anxious to avoid legislation being challenged within the courts. But in all honesty, that is one of the powerful elements of this bill, that we create the opportunity for legislation to be challenged in the courts by children if there is the view that their rights are being infringed. And I think that's an essential part of the approach that we're taking in the bill.
Mary Fee.
Thank you, Presiding Officer, and can I thank the Cabinet Secretary for early sight of his statement. As a long-standing supporter of incorporating the United Nations Convention on the Rights of the Child, I welcome the announcement that was made by the First Minister yesterday and the statement and commitment that has been given by the Cabinet Secretary today. The bill has widespread support, not just in Parliament, but in civic society. And delivering its aims will require a full understanding of children's rights and will require appropriate funding. And the 2 million funding package sounds low to achieve the full aims of incorporation. So can I ask the Cabinet Secretary how the Scottish Government will ensure that those who will be more impacted in delivering this bill, such as local authorities and integrated joint boards, will be appropriately funded to deliver all of the aims of the bill?
John Swinney.
First of all, can I acknowledge the long-standing contribution that Mary Fee has made to this debate on the question of incorporation and the consistent support that she has given for such an approach to be taken. And I'm sure in the consideration of the bill, she will bring that significant expertise to bear in the scrutiny process, and I welcome that. In relation to the question of funding, I've set out the funding approaches that we will take in relation to the implementation programme. But the point I would make to Mary Fee is that what this bill has to do, and it's really one of the critical points in my statement, the bill must enable the creation of a proactive culture of everyday accountability for children's rights. So I don't consider this to be an issue or a question that is solved by the allocation of money to public authorities. It is about changing or making sure the culture of public authorities is operating appropriately to protect children's rights. And I don't think that's about so much the amount of money that's spent, it's the outlook and the perspective of organisations. And many do a very, very good and accomplished task in this respect, but we need to focus on the creation of that everyday culture, and I hope that's the product that comes out of the passage of the bill.
We now move on to open questions. I would like to get them all in, so if we could be aware of the length of questions and answers, please. Ruth Maguire, to be followed by Alison Johnson.
Thank you, Presiding Officer. Can the Cabinet Secretary expand on how the bill will in practice help children realise and enforce their rights? For instance, what support will be available to ensure that all children, no matter their background or resources, or indeed the resources of their parents, are able to do just that?
John Swinney.
Presiding Officer, the bill essentially fulfils the objectives that Ruth Maguire has talked about in two respects. Firstly, by creating the opportunity for young people to challenge legislation in the fashion about which they are concerned. And secondly, by also empowering the Children and Young People's Commissioner to be able to make such interventions into the bargain. So that combination of the individual and the advocacy role of the Children's and Young People's Commissioner is an important balance. I think the other point, and I suspect I will come back to this point frequently in the course of my answers, will be that point on culture that I talked about in my answers to Mary Fee, of the importance of changing the way in which public authorities act to ensure that they are operating fully cognizant of their obligations to fulfil children's rights.
Alison Johnson, followed by Claire Adamson.
Thank you. I warmly welcome today's announcement that the Government intends to incorporate the URC into Scots law, a long-held policy of my own party. Now, I'd like to thank all those who've campaigned to this end for many years, but for this important bill to have maximum impact, for the 54 articles to make a real difference, for these rights to feel really real, It's really key that all who work and interact with our young people understand and know what these rights are. And that's everyone from parents, carers, health professionals, social workers, even sports coaches and many more. So how will the Scottish Government go about ensuring that the learning takes place so that this bill can have the maximal impact that we would all desire? Thank you.
John Swinney.
Officer, I welcome Alison Johnston's support and acknowledge the long-standing commitment of the Scottish Green Party to this question, and I'm glad that we've got to this point where we can engage on this discussion and the passage of this legislation. The key point here is about ensuring that all organisations are operating in a fashion in all of their actions that the respecting and the pursuit of children's rights is an integral part of the way in which organisations operate. And that will be at the heart of the approach the Scottish Government takes of raising awareness and requiring approaches to be taken that reflect the necessity of all organisations to act compatibly with the terms of the United Nations Convention. And that will be what I mean by fulfilling the everyday culture of respecting children's rights within public bodies.
Claire Adamson, followed by Alison Harris.
Thank you, Presiding Officer. One of the lesser-known provisions of the UNCRC relates to the prevention of accidents. In particular, Article 19 guarantees the right to protection from injury, and Article 24 outlines the right to access information, education and support in the prevention of accidents. As a convener of the cross-party group on accident prevention and safety awareness, I have to point out that this aspect of policy is often overlooked, despite accidents disproportionately impacting on children from our most deprived areas. With this social justice issue in mind, can I ask the Scottish Government how it will protect and promote these rights to put accident prevention higher on the political agenda?
John Swinney.
President Officer, I acknowledge the long-standing interest of Claire Adamson in this subject and would make the point that this bill should not be considered in isolation from the wider agenda, which I think is best summed up by the concept of getting it right for every child, which is a policy outlook and perspective which was not, which has been taken forward by this government, but which originated in the previous government that predated this administration. So there has been a long-standing policy commitment within Scotland to work to enhance and to improve the life experience of children within our society. There are many areas in where that has demonstrated very clear progress. We have obviously had a challenging period with COVID, which has made that ever more acute as a challenge for some of our young people. But the work that Claire Adamson has highlighted is important to be reflected in that wider perspective of ensuring that we actively and supportively improve the quality of life of children in our society and their safety into the bargain.
Alison Harris, followed by Fulton McGregor.
Thank you. Cabinet Secretary, you mentioned children challenging their rights in court. So may I ask, how do you actually envisage children paying for this court action? The legal aid system is already fundamentally challenged. So if I was a child, how would I actually take this challenge to court? Would I have to rely on parents? Could you possibly explain?
John Swinney.
Well, there are a variety of approaches that can be taken, not least of which is the one which I gave in my earlier answer, which was about the work that young people can take forward, where the Children Young People's Commissioner has an advocacy role on behalf of children, which is one of the routes. And obviously there are legal aid provisions which are available in that respect into the bargain. But fundamentally, what we are acknowledging in this bill is the importance of children being able to challenge legislation where they believe their rights are being compromised. And I think that's a proposition which opens up a new area of influence for children to exercise their voice, to be empowered within our society, and one which the government fundamentally welcomes.
Fulton McGregor, followed by Pauline McNeill.
Thank you very much, Presiding Officer. And can I also say that I fully welcome the announcement of this bill. Can the Cabinet Secretary set out how the inclusion of the UNCRC in Scots law will complement current children's human rights frameworks used by the Scottish Government, such as the routine publishing of children's rights and wellbeing impact assessments?
John Swinney.
I think the fundamental additional element which will emerge from the passage of this bill will be the requirement on public authorities not to act incompatibly with children's rights. And I think that obligation is the strongest degree of obligation we could have put on public bodies as a consequence of the legislation. There are other approaches which are not as acute as the compatibility duty that we have chosen, and that is designed to signal the importance the government attaches to ensuring that that public bodies operate in a fashion at all times that fully respect the rights of children. And that will be, and the decision to establish the broadest possible scope and perspective of the organisations, the public bodies that will be affected, means that this power or this legislative requirement will have the greatest effect within public policy within Scotland.
Pauline McNeill, followed by Alex Cole-Hamilton.
Does the Cabinet Secretary agree that if the bill is to mean anything to children and young people, then you have to reach ordinary young people and children without a connection to the political class? And that might even mean the Children's Commissioner himself. For example, can the Cabinet Secretary say that a young person who may be in need of mental health services or other necessary life support to secure their well-being and their future, can this bill enhance their lives in a way that they can understand?
John Swinney.
I think there's two particular perspectives in responding to Pauline McNeill's question. One is in relation to the work that is undertaken within our education system, where I know from my own personal experience, both as a minister and as a father, whereby the understanding of the rights of children is now a very central part of our curricular approach within Scotland, and I often hear about it when I get home at night on certain issues. So there is that perspective, but there is also the fact that we can engage young people through organisations with whom they have a relationship. And I think, for example, about Young Scot, which has got a very strong and clear relationship with young people. I don't think it falls into the classification of being part of the political system, but it does have extraordinary reach into young people. And once young people are enabled to understand their rights and to be able to exercise those rights, the challenges that Pauline McNeill highlights, I think, can be fulfilled. But we have to acknowledge the importance of equipping young people with that knowledge and understanding of their rights, which is a central provision of the bill.
Alex Cole-Hamilton, followed by Annabel Ewing.
Thank you, Deputy Presiding Officer. And can I warmly congratulate the Government on bringing forward this bill? It's something I've campaigned for the last 20 years. Several members have already alluded to the fact that this legislation will only be as strong as the access to justice it offers to children through the courts. But that's about more than just striking down bad legislation. The Cabinet Secretary has identified one route through the Children's Commissioner's Office to litigate test cases in the public interest, but that's an exceptionally narrow bottleneck. Children's rights are violated every day. So what additional provisions will this government consider to ensure that any child has at any time the right to legal redress through their courts when their individual rights are violated?
John Swinney.
I think there's a couple of different dimensions in that question. One is about the point that I've made on a number of occasions already to members, which is about the actions and the outlook of public bodies to protect and to properly address the rights of children, and that comes into the operational priorities of different organisations. And that is the easiest way by which the rights of young people are protected, because they don't have to go to court because they've actually had a good and positive experience of being supported by public services. The other is about ensuring that there is a route by which young people can exercise that challenge if they believe their rights have been infringed. And the example I cited about the Children and Young People's Commissioner is a mechanism available through the bill Obviously, we are engaged in a parliamentary process about the bill. I will remain very open to discussing these questions with members of Parliament. I acknowledge the long-standing interest that Mr Cole-Hamilton has had on this subject, and I'm quite sure in the course of the parliamentary proceedings we can discuss how any other routes or approaches can be taken forward.
Annabel Ewing, followed by Jeremy Balfour.
Thank you, Presiding Officer. I very much welcome the Cabinet Secretary's clarification that all devolved bodies, as well, of course, as the Scottish Government and the courts, will be bound by the obligations to respect children's rights under the bill. In terms of how this will operate in practice, can the Cabinet Secretary advise as to whether the declarations on compatibility approach of the Human Rights Act will in fact be followed here under this bill?
John Swinney.
The approach the government intends to take, or a preferred policy, would be to require all legislation passed in future to be compatible with the UNCRC, with the courts having to strike down incompatible legislation. Now, I explained in my statement the challenge about future legislation. So the bill provides for two different remedies in respective legislation which is found to be incompatible. In relation to the primary legislation which predates the bill, the strike-down provision will exist for the courts, and in future legislation, the government will be required to set out to essentially make a compatibility assessment of any primary and secondary legislation that we're bringing forward to ensure that is compatible with children's rights.
I've decided to allow the last two questions, but if you would be succinct, it would help. Thank you, Jeremy Balfour, followed by Joan McAlpine.
Thank you, Deputy Presiding Officer. Can I ask the Cabinet Secretary to set out any additional rights and protection disabled children will receive in line with Article 23?
John Swinney.
Article 23 gives young people the opportunity to ensure that their own particular interests and perspectives can be fully respected, and I think it is drafted. One of the criticisms of the UNCRC is that it is not, in all of its language, an absolutely precise document. I think that's a good thing, because what that then leaves open is the scope for Parliament to take a maximalist approach. It leaves open the scope for the courts to take a maximalist approach in how they protect the rights of children and young people, and particularly those children and young people with disabilities that Mr Balfour raised.
Joan McAlpine.
Thank you. Does the Cabinet Secretary agree that it is crucial that in this Parliament we take an outward-looking international approach to human rights through UNCRC incorporation, particularly at a time when the UK Government is diminishing its international standing through leaving the EU and previously even threatening to withdraw from the European Convention on Human Rights?
John Swinney.
So one of the, I think, one of the great strides forward that's taken place during my lifetime has been the enormous progress that has been made on the human rights of individuals, and so much of that has emanated by the thinking that has emerged through the European Convention on Human Rights and its significant influence on the Human Rights Act in the United Kingdom. So I very much hope that the incorporation of the Convention into domestic legislation into Scots law will be viewed as a signal by this government and this Parliament of our determination to take a human rights-based approach to all of our policy outlook and interventions. And I think that sets out a direction about who we are and what we aspire to do within our society, which respects the values which are enshrined on the mace of the Parliament that sits in front of us and in front of the presiding officer, and which reflects very much the country that we want to be.
That concludes questions on the statement by John Swinney. Can I remind members that social distancing measures are in place across the chamber and the campus, and take care to observe these measures over the course of this afternoon's business, particularly when entering and exiting the chamber.